Hi, I'm Tom Spiggle with the Spiggle Law Firm, where we represent people who have been fired or afraid that they might be. We represent folks in the DC metro area and throughout the state of Virginia. I am thrilled to be joined today by somebody, an attorney who works in our office, Evelyn Coe. Welcome, Evelyn. You've talked to us before, and I appreciate it. So, what's on top of mind today?
So I actually wanted to kind of do a overview about 3 exciting changes that are expected to come in the employment law field in 2023. So for the first one, I want to talk about the Family and Medical Leave Act, the FMLA. It is a federal law that allows eligible employees to take unpaid leave for a certain family and medical reasons. And this, the FMLA is expected to expand this year and making it easier for employees to take leave for reasons such as caregiving, military service, and domestic violence. And I heard that the definition for family is supposed to expand to siblings as well. And then also, I also heard that it was supposed to cover not just companies with 50 or more employees, but they're supposed to actually lessen that and cover employers who work for companies cover employees who work for companies with 25 or more employees. Another change is coming to the Equal Pay Act.
Just to interrupt you real quick right there, Evelyn.
Sure.
Evelyn, can you hear me? Let me just interrupt you real quick.
Yes.
Just so folks understand, under the Family Medical Leave Act, right now, you only covered if your employer has 50 or more employees within a 75-mile radius, which obviously leaves out a lot of smaller employers, which means you're not entitled to protections under the FMLA. So it sounds like that's expanding, so they will drop the threshold below that 50 employee mark, which is a big deal.
Yes, so it's expected to, so it hasn't been finalized yet. So hopefully, fingers crossed. The next one I wanted to talk about was the EPA. So the EPA is a federal law that prohibits employers from discriminating against employees on the basis of sex in the payment of wages. And the EPA is expected to further clarify and strengthen the act, making it easier for women to enforce their rights under the law. And this is expected to make it clear and applies to all employees, regardless of their job title, education, or experience. And this means that employers cannot pay women less than men for doing the same job, even if the women have less experience or education than the men, which is very exciting.
Yeah, and the EPA, you're talking about the Equal Pay Act, and
Yes.
I think it's worth pointing out it usually is women who are paid less than men, but the statute applies equally. So you can't pay someone less on the basis of sex. So it could be a man who is paid less than a woman, but sadly it is mostly
Yes.
women who are in that category.
Yes, exactly. The final one that I wanted to mention today was the Pregnant Workers Fairness Act. And this is actually an amendment to Title VII. And this is an act that prohibits employers from denying reasonable accommodations, such as a lighter workload, intermittent breaks, or even seating changes for employees experiencing pregnancy, childbirth, recovery, and related medical conditions. Under the ADA, if a pregnant employer needed an accommodation that would impede them from doing the essential functions at work, the employer had every right to deny the accommodation. But under this new act, an employer must meet a temporary accommodation unless they can show undue hardship. And this act was signed by President Biden, I believe it was in December last year.
Yeah, that's right. Because it really kind of filled a hole, right, where prior we had the Pregnancy Discrimination Act, which prevented, disallowed companies from discriminating against women on the basis of pregnancy, but it did not require specific accommodations, right? So we saw crazy cases where, because normally under federal law, you're only entitled to a workplace accommodation if you're covered by the Americans with Disabilities Act. And, most courts found that pregnancy was not considered a disability, which is probably the right thing. We don't call pregnancy, a normal pregnancy a disability. So you had women who, were not covered under the American Disabilities Act. They were pregnant, and they would need some kind of just basic accommodation, right? Like, I'm having to drink a lot of water, so I need more bathroom breaks. And we had weird cases where employers were saying, "Sorry, no dice. We're not required to accommodate you." And the women would either quit, sometimes be fired, and that was perfectly legal. So the Pregnant Workers Fairness Act kind of plugs that hole, right, and says, hey, pregnant women are entitled to reasonable accommodations, so they can do, whether it's they need to get up and walk around or take a break or whatever an accommodation might be to allow them to continue to work. Unless, as you point out, there's an undue hardship, which is really high burden for employers to meet. So it's a really big deal, and I think those are three really important changes. Some of which have already happened, some of which may happen, which really will provide a lot more protection to women in the workplace.
Exactly. Yes. Thank you, Tom.
All right, Ellen, thanks so much for that. That was very helpful, and we will let you get back to the next thing you got going on.
Thank you. I hope you have a good day.
All right, you too. Bye bye.